Tasha Sumner, Senior Counsel at Husch Blackwell in the Healthcare Regulatory Practice Group. We're very excited that you are all joining us today for this hour of hot topics in psychedelic law. I'm one of the co-founders and co-leaders of the firm's Psychedelics and Emerging Therapies Practice Group. Among other things, I advise clients on regulatory matters inherent in new drug development. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later by email. A PDF of the presentation is available in the program materials folder. This program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. Presenting with me today are Karen Luong and Christopher Miles. Karen is a partner in our Los Angeles office and is a co-founder and co-leader of the firm's Psychedelics practice group. Karen's background is in commercial and business litigation and product liability defense with a focus on toxic products. She currently serves on the board of Women in Psychedelics Network. Christopher is a partner in the Technology, Manufacturing, and Transportation Unit of Husch Blackwell in Kansas City, Missouri. Christopher represents creditors, debtors, and receivers in all types of insolvency proceedings, from foreclosures to bankruptcy to receiverships to consumer and commercial litigation. He currently serves on the board of directors for the Kansas City Bankruptcy Bar Association, where he served as president in 2019. All right, well, that's all for the housekeeping, so we will get started with our program. So I'm going to be starting off here talking about sort of the overview of what we're doing today. So we've got an overview of state and federal law, and that includes a discussion of the recent FDA guidance on psychedelic research. We're going to talk a bit about the Ames versus DEA case. Then Christopher is going to talk about lessons from cannabis and their applicability to psychedelics. And then we're going to talk a bit about risk mitigation. All right, so I'm going to start off a little bit with some overview of state and federal law. So as I'm sure many of you know, all of the psychedelics that are being researched all fall under the Schedule 1. Which you can find the scheduling regulations at 21 USC 811 through 814. And then I'm going to talk a little bit, after just briefly defining what Schedule 1 means, talk about a couple of recent federal proposed legislation, and then I'm going to talk about the roles of the DEA and the FDA with respect to Schedule 1 drugs. 21 USC section 811 is the authority and the criteria for classification of substances. And then 21 USC 812 is the actual schedule. So that lays out all of the different schedules 1 through 5. So Schedule 1 drugs are substances, chemicals with no currently accepted medical use, that lack evidence of safety and have a high potential for abuse. So examples of these are things like heroin, LSD, marijuana, cannabis, ecstasy or MDMA. I didn't put on here psilocybin, but that's a big one, and peyote. Now, the reason that where a drug falls in the schedule is important is because Schedule 1 drugs, the only legal use is for approved research and no other use. And the research on Schedule I drugs can be quite onerous. There are a lot of regulations for research generally, but there's additional things that have to happen with Schedule I drugs. So some senators, Senator Paul and Booker, in 2022 had proposed legislation, which is the S689H1393, which is called the Breakthrough Therapies Act, which would amend the Controlled Substances Act to define what is, quote, currently accepted medical use with severe restriction. And then that was updated fairly recently. Again, that none of this has been approved legislation, but just recently they added some extra or additional legislation sections to it. And so what this would do would be to allow drugs that are designated as breakthrough therapy or qualify for a waiver under the Food, Drug, and Cosmetic Act to be moved to Schedule II, which is a really big deal because Schedule II drugs are much easier to research. The addition was that any drugs that had been moved from Schedule I to Schedule II could be moved back to Schedule I if they no longer have a currently accepted medical use with severe restriction. The other very recent federal proposed legislation is Douglas Mike Day Psychedelic Therapy to Save Lives Act of 2023. That is very difficult to say. And what that does is it directs the Secretary of Defense to provide grants for further research into the use of psychedelics to treat PTSD and traumatic brain injury in active duty service members. And that one is pretty important as well, because federal grants are very difficult to obtain and have been actually almost impossible until recently to study and research Schedule I drugs. Now, the DEA, if you do want to do research on Schedule I drugs, there are some things that you have to do up front with the DEA. So any researcher who wants to conduct research with a Schedule I has to be registered with the DEA and get a specific Schedule I license. And a separate registration is required for any place where research is being conducted. So if you have multiple sites, for instance. And then once that happens and you're able to get a certificate of registration from the DEA, Form 223, then you keep that at each of those locations. And then in addition to completing the Form 225 application, a Schedule I researcher must file and receive approval for a research protocol. And so that protocol can be found at 21 CFR 1301.18. Both of these code sections here that I have on this slide require HHS to review and comment on the scientific merit of the studies and qualifications of investigators conducting research with Schedule I controlled substances, and then to respond on those matters to the DEA. So Section 1301.18 sets forth the required format and the information for the protocol to conduct the research. Now, alternatively to that, an applicant can submit 3 copies of their IND together with a statement of security provisions. And then Section 1301.32 states that the controlled substances staff, which is part of CDER, which is the Center for Drug Evaluation and Research, which is part of the FDA, will review the Schedule I application protocols, or the IND, received from the DEA, and then will advise the DEA on the qualifications and competency of the applicant, as well as the merits of the protocol. So there is a lot of interplay when you want to do Schedule I research between the FDA and the DEA, and they work together. And so you need to be in contact, obviously, with both of them. So I'm going to pass this now over to Karen, who is going to talk about the new FDA Draft Guidance.
Hi, everybody. I'm Karen Luong. I'm a partner in the firm's Los Angeles office. And another hot topic that we wanted to talk to you about is something you might have seen in the news about a month ago. And this came out on June 23rd, right at the tail end of when many of us were at the Psychedelic Science Conference in Denver. And this is the FDA's draft guidance for the FDA's first draft guidance on designing clinical trials for psychedelics. That is exciting for a number of reasons. One of them is that the FDA is finally officially recognizing the progress that the science has made and acknowledging the potential of this research and establishing official draft guidelines for it. And it's also very interesting to see in this guidance what the FDA in its independent consideration focuses on and what it doesn't focus on, and also certain areas of concern that FDA identifies. Now, while the draft guidance is light on specific recommendations, the document does provide foundational considerations for researchers developing psychedelic drugs to treat medical conditions. Notably, I think one of the first things the guidance does is that it defines the term psychedelics, and it includes, it states that the term psychedelics includes 5-HT2 agonists, which are always sort of been understood to be classic psychedelics like psilocybin and LSD, but also includes in this definition enactogens or empathogens like MDMA. That was interesting to note. And psychedelics drugs will have the same evidentiary standards as all other drugs, but some of the unique considerations that FDA identified include intense perceptual disturbances and alterations to consciousness that may last for hours, the incorporation of psychological and behavioral intervention, and the possible rapid onset and long-term benefits after one or a few doses. Now that last point was encouraging to me because I think it's a hat tip to the MAPS MDMA clinical trial results and a growing number of very promising ongoing studies that stand to really challenge the status quo of classical pharmaceuticals as drugs that you might have to take once a day, every day for an undetermined time period, maybe for the rest of your life, versus some of the clinical trial results that are coming out for psychedelic-based treatments that show efficacy after one or just a handful of treatments. So it's great that the FDA is recognizing that. There is a lot in this guidance, even though it's only 11 pages long. It's packed full of information. And so for those of you who haven't read it or might not read it in the near future, I want to do my best to give an overview of the general recommendations that's in it, just that you know what's in this guidance because it's relevant to what's going on in this entire space. So let's start with chemistry, manufacturing, and controls. This section of the draft guidance doesn't propose any new or unique recommendations for psychedelic drugs, but what it does do is suggest previous and existing guidance that sponsors and investigators can look to. Now, in the guidance, FDA mentions botanical drugs, which consist of plant material, algae, and macroscopic fungi. This class of investigational drugs is covered in the botanical drug development guidance that the FDA released in December 2016. So FDA refers sponsors and investigators to that guidance. However, it does note that botanical drug development guidance does not cover psychedelic compounds that are genetically modified. It doesn't cover compounds that are produced by fermentation of yeast, bacteria, or plant cells, or that are highly purified substances. Those compounds are not considered botanicals, even if they are derived from plants or fungi. Another thing that the new guidance points to are other established policies that on current good manufacturing process, or CGMP, and the draft guidance points at the 2008, 2003, and the last guidance there is the year 2000, existing guidance up on the screen that FDA has already published. And the guidance also mentions that sponsors and investigators need to be sure to provide sufficient information related to the identification, purity, and strength of the investigational drug substance and drug product at each phase of the trial. On to the non-clinical section of the draft guidance. Generally, all non-clinical testing should follow the ICH guideline. That's the first bullet point on this slide. It's the long title is up there. That was adopted by the FDA in 2010. But this new draft guidance adds some unique considerations of non-clinical psychedelic drug development. First, an IND clinical study can begin without typical animal toxicology testing. This can happen when there is extensive human exposure and information available from previously conducted clinical studies and no serious health concerns have been identified. In the case that there is not adequate information on human exposure, non-clinical data would be required before a clinical study can begin. Now, next, because the conditions being studied are often chronic conditions like PTSD and major depressive disorder, non-clinical studies to support chronic or chronic intermittent dosing should be provided if the treatment is not durable or repeat dosing is expected. The number and types of clinical studies needed to support the approval of a marketing application is going to depend on the specific treatment plan. Now, finally, the FDA raises concerns about cardiac valve stiffening from long-term exposure to 5-HT2B agonists. And if you've been following the science on this, this is a concern of many recent studies. Sponsors, FDA says, should assess functional activity at the 5-HT2B receptor subtype related to the psychedelic drug. And if the drug is an agonist, then a microscopic evaluation of the heart should be conducted to determine the potential for heart valve thickening. The guidance also identifies multiple areas related to the clinical pharmacology of psychedelic drugs. Now, first, it states sponsors should evaluate the effect of a high-fat meal on the pharmacokinetics of a psychedelic that's taken orally. This should occur early in development and may inform the clinical study design going forward. FDA also highlights several drug-drug and drug-disease interactions that should be considered, including the metabolism of psychedelics might be affected by the use of cytochrome P450 enzyme and transporter-mediated drugs or gastric pH-dependent drugs. It also highlights the chronic use of selective serotonin reuptake inhibitors or SSRIs or monoamine oxidase inhibitors, MAOIs, might reduce the effect of psychedelics. Those drugs are often used to treat depression. It also highlights that psychedelic effects may be more potent with the acute use of SSRIs or MAOIs, as well as with the chronic use of tricyclic antidepressants or lithium. Now again, FDA notes the long-term exposure of 5-HT2B agonists might lead to heart valve thickening and suggests that sponsors should not use subjects with pre-existing valvopathy or pulmonary hypertension in multiple dose studies. Citing a lack of current understanding of the dose-response relationship for most psychedelic drugs, FDA wants sponsors to take steps to understand this relationship better, especially with respect to efficacy and safety. The FDA draft guidance also includes guidance on abuse potential assessment. Now, because psychedelics act on the central nervous system and produce psychoactive effects, an abuse potential assessment will need to be conducted. Data from this assessment and a proposal for drug scheduling under the Controlled Substances Act is required to be included in a new drug application submission. FDA notes that if a drug is approved, some of this information may help with rescheduling Schedule I psychedelics under the Controlled Substances Act. The FDA guidance on abuse potential assessment mentions the existing 2017 guidance for the industry that's titled Assessment for Abuse Potential of Drugs. Some psychedelics have already been the subject of investigations in scientific literature. And in this scenario, sponsors should use scientifically valid, published investigations to support the abuse potential assessment. When that information is not readily available, sponsors must conduct a full abuse potential as outlined in that 2017 guidance. In psychedelic trials, all abuse-related adverse events, such as euphoria, hallucinations, simulation, and emotional lability should be recorded. Abuse-related adverse events should be monitored and reported even if they are hypothesized to be associated with a therapeutic response. Investigators and session monitors should be trained to record all abuse-related adverse events, including psychedelic ones. And the incidence of these abuse-related adverse events in comparison to placebo or active control in studies should be reported by study, population, and dose. Draft guidance also says that depending on whether the drug will be used continuously or acutely, the study may warrant an assessment for physical dependence. Dependence assessments are usually conducted only after the therapeutic dose range is determined, which typically occurs when phase 2 clinical studies are completed. FDA recommends submitting proposed protocols to the agency for review and comment before conducting these abuse-related studies. Finally, sponsors should be prepared to discuss an abuse potential assessment plan with FDA in early stages of the IND drug development. Now on to the draft guidance on clinical studies. The FDA notes that psychedelics present unique challenges for conducting adequate and well-controlled, or AWC, studies. And for example, a traditional placebo might not work because of the intense perceptual disturbances that psychedelics might cause. And FDA suggests alternatives, including the use of subperceptual doses or using other psychoactive drugs that mimic the effects of psychedelics. Another concern is the use of psychological support or psychotherapy during treatments, which FDA has a concern might obscure the effectiveness of the drug. That is, a good study should be able to differentiate between the effects of psychotherapy alone versus the psychedelics component. And this is the only quote that I'm going to read directly from the guidance, and because it's interesting to me because it states that, quote, as of the publication date of this guidance, the contribution of the psychotherapy component to any efficacy observed with psychedelic treatment has not been characterized. And that's interesting because it's the FDA sort of taking a cautionary approach to this and stating that it whether or not psychotherapy is effective on is an effective part of the treatment has yet to be determined, and that it'll be examining and analyzing studies as they come out on that. FDA noted a factorial study design might be helpful in isolating the efficacy of the drug from the psychotherapy. And in this case, the investigator would need to run trials, including 1, a psychedelic with psychotherapy, 2, psychedelic alone, 3, a placebo with psychotherapy, and 4, placebo alone. FDA recommends that sponsors should plan to characterize the durability of drug treatment. For treatments like chronic illnesses, the effect of the treatment should be evaluated at 12 weeks, and then the subjects should be monitored for symptoms, recurrence, or the need for repeat dosing for a year after. In this draft guidance, the FDA gives recommendations for safety monitoring during clinical trials. They suggest having 2 monitors for the duration of the entire treatment session, a lead monitor and an assistant monitor. The lead monitor should have graduate level professional training, clinical experience in psychotherapy, and be licensed to practice independently. The assistant monitor should have a bachelor's degree and at least 1 year of clinical experience in a licensed mental health care setting. In addition to 2 monitors, if the lead monitor is not a physician, then there should be 1 licensed on-call physician who is able to reach the clinical site in 15 minutes in an emergency. Finally, FDA suggests that clinical trials may be subject to a clinical hold if they don't include safety monitoring according to these recommendations. Now, to recap, The new draft guidance provides a number of foundational considerations for sponsors and investigators as they plan to develop psychedelic drugs to treat a variety of medical conditions. FDA pointed to previous guidance on clinical studies that should be followed, and they also raised unique considerations for the design of clinical trials specifically involving psychedelic drugs. A final note that this is a draft guidance and that there is a comment period, and that the FDA will accept and is accepting comments from the public. So if you read through the guidance, or if any of what I've said strikes a chord with you, or you have any comments that you want to give to the FDA, they are welcoming this. You can give comments at regulations.gov until August 23rd, 2023. And I'm going to pass it back to Natasha right now, who is going to talk about state legalization efforts.
All right, thank you, Karen. So I'm going to talk a little bit about a couple of different areas where we're seeing states active in psychedelics. So we have the area of legalization, which are all Oregon and Colorado, and then we have decriminalization, and then what we're calling the working groups. And that is, these are examples, there are others, but Utah and Texas. So I'm sure many of you have heard of Oregon Measure 109, which there is the statute now, ORS 475A. I'm not an Oregon attorney, so I'm not going to go into this in any detail. But essentially what this is doing is setting up these state licensed service centers, and someone can go there and get, psilocybin therapy. And I know that they either have started the first one, or I think that they're fairly close. But I'm sure you can Google it, and we'll probably end up finding out more than I know right now. And then Colorado Prop 122, very similarly, which is the use of psilocybin in state-regulated healing centers, where, again, people can receive medically guided psilocybin treatment. Now, even though these states have legalized it at the federal level, these are all still illegal. And I'm sure, as many of you know from cannabis, there were many challenges around that conflict between state and federal law. So will be very interesting to see what happens here. Now, Decriminalize is a little bit different. So here I'm in California, Northern California. So in Oakland, which is in the Bay Area, they have decriminalized the use and possession of what they're calling entheogenic plants, which includes all of these things we're talking about. And essentially what that does is basically they're taking the resources that they normally would put towards, enforcement of the laws and imposing penalties, and they're putting those funds elsewhere. And that's the same thing with DC. And this is just a quote: "Police shall treat the non-commercial cultivation, distribution, possession, and use of entheogenic plants and fungi among the lowest law enforcement priorities." And then we have the working groups. So as an example, we have Utah, which is HB 167, the Mental Illness Psychotherapy Drug Task Force. And what that did was establish 4 work groups that were to provide recommendations in the context of the most promising currently available evidence on MDMA for the treatment of PTSD and psilocybin for the treatment of depression. And essentially what they've done, that report has come out, and they're basically going to hold off on doing anything further, and they're waiting for the FDA to do what they need to do, which is hopefully to legalize MDMA, which will likely be the first one in the treatment of PTSD. In Texas, they are in collaboration with Baylor and the Veterans Affairs Medical Center conducting clinical studies with psilocybin for treating veterans' PTSD, and they will also carry out a scientific review to evaluate the therapeutic efficacy of psychedelic substances, and then they'll provide quarterly reports. That's HB 1802 if you want to read about that. So I'm going to hand this now back to Karen, who is going to talk about a very interesting case in the Ninth Circuit.
Hi, everyone, again. The next thing I wanted to talk about was a case that is very near and dear to my heart. It's currently pending in the United States Court of Appeals for the Ninth Circuit. Lead attorneys for petitioners are Catherine Tucker and Matthew Zorn, and my firm had the privilege and honor to be able to represent a coalition of physicians in one of the amicus briefs or friend of the court briefs that were submitted to the Ninth Circuit for this case. I have a couple slides that I'm going to cycle through during this talk, but really I just wanted to explain this case to you the way I explain it to my friends. Because this case is an interesting one, and it will affect every single person who's listening to this now, and every single person in the United States potentially, because it is about how we treat patients at the end of their lives, how we treat people at the end of their lives, and who decides how we treat them. Now, Dr. Sunil Agarwal, the petitioner in this case, is a palliative care doctor, meaning he treats people at the very end of their lives. He is in Washington State. And what Dr. Agarwal wanted to do was he looked at the very promising studies and promising science and real life experience out there that says that psilocybin is a very effective treatment for end-of-life patients that are dealing with existential distress and anxiety and despair that comes with knowing that you're at the end of your life. And what he wanted to do was he wanted to provide psilocybin therapy to his patients to help with that. And it is very important to note that he, in this case, Dr. Agarwal is advocating psilocybin therapy within the completely legal framework that currently exists, because 41 states and Congress, including the state of Washington, where Dr. Agarwal is located, have enacted legislation called Right to Try legislation. And what Right to Try does is it says that people with life-threatening illnesses, and that includes, for example, terminally ill cancer patients, have a right to try. They have a right to be prescribed and to try eligible investigational drugs. Now that's the term of art. Eligible investigational drugs do not include, for example, just natural psilocybin mushrooms in this case. There are 2 psilocybin drugs that currently fit into this category, and they have passed stage 1 clinical trials. So they have passed basic evaluation for safety, for patient safety. And they have not been approved by the FDA yet. But the whole point of Right to Try is that patients who do not have a lot of time left also don't have the time to wait for a drug to be approved by the FDA, which can take years. So those are the psilocybin drugs that Dr. Agarwal was seeking to provide to his patients. So within the legal framework of existing Right to Try laws and the 2 approved drugs that fall into an eligible investigational drug. So he wanted to provide this treatment to his patients, but he did not want he didn't want to lose his license to practice medicine for unauthorized use of a Schedule I substance. So he asked the DEA to make a determination, like, DEA, will you let me know if I can provide these under Right to Try to my patients? And eventually this is a process that took several years. It punted back and forth between the DEA and the Ninth Circuit. Eventually the DEA said, actually, no, you can't. So this case, Ames versus DEA, is an appeal of the rescheduling denial, because eventually Dr. Agarwal directly petitioned the DEA to reschedule psilocybin from Schedule 1 to Schedule 2. And it should be noted that a rescheduling from Schedule 1 to Schedule 2 it would still mean that psilocybin is very, very highly controlled, and the main difference between access for Schedule 1 to Schedule 2 drug is the Schedule 2 drug is much more accessible for research and medical purposes, and that's what Dr. Agarwal is seeking. When his petition to reschedule was denied, amicus briefs came in from all over the country with bipartisan support from researchers, from professors, from veterans' right groups, from NORML, and from clinicians. And my office represented the clinicians' brief. What we argued on behalf of the clinicians was that one of the definitions of a Schedule 1 drug is that there is no accepted medical use. And is it appropriate, or wouldn't it be appropriate for doctors to be included in deciding whether a drug has an accepted medical use? And why, and is it appropriate for the enforcement arm of the US government to be making that decision versus the doctors who are, who are actually on the front lines and able to provide this treatment? Oral arguments in this case are currently tentatively scheduled to happen in mid to late October 2023. So this is a case that it's one to watch. It has the potential to reschedule psilocybin from Schedule 1 to Schedule 2. And also it just deals with a very timely and very interesting issues about the decisions we make to treat people at the end of their lives. The next thing that we're going to be discussing is I'm going to pass this on to Chris, who will who has a lot of useful things to say and useful things to know in the event things don't happen as planned in your business or your clinical trial, and in the event you run out of money or you become a debtor, and what resources are available in the insolvency process.
Thank you, Karen. Good afternoon, everyone. You probably see this slide and say, what on earth are we talking about cannabis for? I'm trying to attend the Psychedelics CLE. The reason is because cannabis got there first. If you looked at one of the earlier slides from my colleagues, you saw the states that were sort of leading the charge with respect to increasing legalization efforts in the psychedelic space, and it is the same actors that 10 or 15 years ago started leading the charge with respect to cannabis. It's Colorado, it's California, it's Washington, Oregon, and so forth. And so we can learn a great deal, I think, by looking back at the lessons from the insolvency space with respect to cannabis and looking forward to the future and saying, gosh, in the next 10 years, what are people that are either directly producing and marketing and selling psychedelics products, what are they going to face, as well as those companies which do business with those entities? What challenges might they face in the insolvency space? So, a brief history. 2012, Washington and Colorado legalized cannabis for recreational use. Already at this time, California had approved it for medical use, and California would later, I believe in 2016, approve cannabis for recreational use as well. And so a lot's happened since then. The only thing we can definitely say is that when a state legalizes recreational cannabis, they tend to win Super Bowls if you look at within 5 years. If you look at Colorado, Washington, California, Missouri, they've all had winning Super Bowl teams, but I'll let wiser heads opine on that. By the end of the decade, we expect cannabis industry to exceed $50 billion. At this point, 2023, 38 states have legalized it for medical use and 23 for recreational use. But still, it remains a controlled controlled substance under the CSA, Schedule 1. And so we have this sort of dual legality, which is more than likely the same problem we're going to have with psychedelics in the coming years. And that's why it's relevant to take a look at where the cannabis industry has intersected with insolvency. And one thing that we learned very early is that cannabis producers, not only producers, but cannabis adjacent business businesses had trouble accessing federal bankruptcy courts, given that the business is an ongoing CSA violation. And almost universally, these debtors that get into financial trouble have not been able to access the federal bankruptcy courts for this reason, for several reasons actually, which we'll go through. But also, I want to note that if you are a creditor of one of these entities and you want to proceed with enforcing your rights in a federal district court, you're going to similarly have a problem. If you can find a federal judge that will, if, for example, you took a security interest in a marijuana producer's crop, and you go into federal court and say, I would like to enforce my security interest and get a judgment and an order to surrender whatever's left of the crop so I can resell it. A federal judge is probably not going to grant you that relief for many of the same reasons. And even if you got very lucky and got a federal judge to give you an order awarding final possession of that particular piece of collateral, you go to the federal marshals to enforce it, and they would likely refuse you and say, we don't seize cannabis products, our friends down the hall at the DEA do. And so you'll be left, like many debtors, with state law remedies, and we'll talk about those here in a moment. So one thing we have to first consider is your business directly producing a substance or directly marketing and selling a substance that's controlled and therefore illegal under the federal regime, but legal under a state regime? Or is it simply an adjacent business? And so in the cannabis space, we've seen cases where you have landlords for producers or sellers be unable to access certain federal bankruptcy protections, as well as equipment suppliers, thinking of, for example, industrial grow lights. These have all been caught in the net, if you will, by the CSA, because as you see from the slide, for landlords, you cannot, quote, knowingly, openly lease, rent, use, or maintain any place, whether permanently or temporarily, for the purpose of manufacturing, distributing, or using any controlled substance. And this is, several landlords have run afoul of this, even if they have a vast, say, warehousing system, and only a very tiny fraction of it is used to house or store any kind of cannabis distribution or manufacturing operation. And it gets very interesting also with financiers. Most private financiers of these sort of enterprises have multiple types of businesses in their portfolio, and there's a question as to whether the fact that they've financed a cannabis operation of some variety taints their entire operation such that they can't access federal bankruptcy courts. And the courts have rejected this for a number of reasons. One is good faith. You have to file in good faith. You have to proceed as a debtor in good faith, and you have to propose a plan of reorganization if, in fact, you are using Chapter 11 in good faith. Also, you cannot propose plans that are otherwise not forbidden by law. And you also have to propose a plan or operate a Chapter 7 in a way that would not be considered a, quote, abuse under the code. And many bankruptcy courts have said that if you are doing something that is illegal under federal law, you can't use another federal statute to get around that. And where it gets very interesting is when, again, you have these adjacent businesses. Colorado, which is in the 10th Circuit, has taken a rather strict line on this, which is to say that if you're driving as a debtor trying to reorganize, you're driving any income from criminal activity, your case is going to get kicked out and your plan will not be confirmed. The 9th Circuit has taken a more measured approach, which is to look at the specifics of the plan. So if we go back to our hypothetical landlord, you might have an analysis of, all right, I have 5 huge warehouses, and in one of them, one of the bays that constitutes, say, 3% of the square footage, we have a staging area for cannabis distribution. In that particular case, you might have a bankruptcy court be more willing to approve a plan or more willing to allow that landlord debtor to access federal bankruptcy protections. Likewise, with our fictional financier, who is going to have a very tiny part of his portfolio deriving from the cannabis industry. He may, under a more relaxed regime in the Ninth Circuit, be able to access federal bankruptcy protections. Just another quick point. Some courts have found that gross mismanagement, that dealing in any type of illegal activity triggers that automatically under the code, and therefore you're not able to get a plan confirmed. And several courts have used multiple, have dismissed it for multiple of these reasons. They're not mutually exclusive. So the analysis you'd probably have to do is where in the marketing, distribution, production of psychedelic therapies your business falls, and then do an analysis from there if you're trying to access federal bankruptcy protections, again, if your business gets in trouble. But mostly because it is so difficult to access federal protections, most, at least right now, most parties are stuck with state law remedies, and there are a number of those available. The most common is a receivership. This is essentially where you hire a court-appointed person, a receiver, to step into the shoes of the debtor. These are mostly initiated by creditors, and creditor generally, although the receiver is, quote, independent and supposed to work for the benefit of all creditors, usually the initiating creditor is ultimately driving the boat, practically speaking. And so the debtor will lose control that way. And one of two things is going to happen out of a receivership. Either the business is wound down and liquidated, or it is managed and then sold as a going concern to a third-party buyer. An assignment for the benefit of creditors has a lot of the features of a receivership. It's got some distinctions where it is more geared to liquidation than a reorganization and sale. Most states have some form of assignments for the benefit of creditors, or ABCs. California has one of the most developed ABC statutes and regime, and given that California's been on the forefront with respect to both cannabis and psychedelics, that's going to be an option for many creditors in this space. You also have the option of corporate wind downs. Every corporate code in all 50 states has a provision or provisions to wind down and liquidate a business. Some are better than others, but none of them, I think, were actually prepared by insolvency lawyers. They were put together by corporate lawyers. And you have an option to go judicial or non-judicial. Judicial is more expensive but safer, and often a judicial wind down will end up looking very much like a receivership. But again, there's some advantages there because the debtor can retain a little bit more control. So I wanted to wrap up and just note some of the issues with state-based receiverships. First of all, at least in Colorado, we've seen that the real value of at least producing businesses, cannabis businesses, is the state-issued license. And putting on our guessing cap, in a future regime in which psychedelic therapies are legalized, there will probably be some sort of licensing regime depending on what state you're in. And you have this practical problem where who do you get it, where you have the question of who is going to be a receiver. So a common receivership would be, say, multifamily housing. And you can find a dozen people in any city that have some experience with property management, things like that, and they can be appointed as a receiver. The pool gets a lot smaller, especially with such a new industry, and newer still with respect to psychedelics. The pool is very small when you're asking someone, okay, well, how much experience do you have with respect to managing or liquidating these types of assets. And that's been certainly an issue in Colorado thus far when it comes to cannabis receiverships, and no doubt will be for the psychedelic space on a going forward basis. Also, Maryland, just want to note, has made some attempts to modify their statutory regime to sort of address this problem, and these are fairly new developments. So the answer is it working? The answer is we'll see. So just in sum, I would say that going forward, there is no reason to believe that psychedelic therapies are not going to blaze an identical or at least very similar path to legalization as has cannabis. The broad acceptance is going to continue, and when that happens, like with any new industry or existing industry, you're going to have winners and losers. And so now's a good time to kind of be thinking about those types of issues with respect to those businesses that don't succeed, and what's the best way for creditors to get paid, what's the best way for debtors to keep the wolf from the door. And I will hand it back to my colleagues to close us out with risk mitigation.
All right, I'm going to change topics a little bit and talk to you guys about risk mitigation. And at this point, I mean, I don't know how much weight the phrase "trust me, I'm a lawyer" carries, but really, I mean, trust me, I'm a product liability, toxic products defense litigator, and I'm in the room to deal with the bitter end of what happens when companies don't adequately mitigate their risk. And you know, unfortunately, despite all my efforts, and my job still exists, and people still get sued all the time. And I hope I can give you some tips on things you should be aware of to help be prepared for and help mitigate your company's risks. A lot of companies we talk to are startups or are smaller companies. Even if you're a big company with very deep pockets, a civil lawsuit has the ability to derail your business, or at least divert a substantial amount of resources that you could be spending on growing the business. It's something I tell clients a lot is when it comes to litigation, it is kind of unfair or totally unfair, I guess, but you don't have to have done anything wrong in order to get sued. You could have done nothing wrong, but guess what? If you are a target, if you get sued, you still have to defend yourself. And that, even if it's just to get your case dismissed early on, can involve very significant legal fees. And there is no way to predict all the risks that you'll run into and how to avoid them all, but here are some things that you should keep in mind. For commercial risk mitigation, that is risk mitigation outside of the clinical research context. And, and I think this is relevant to all businesses. It's just important to consider as a risk and to acknowledge as a risk that as it stands today, the only psychedelic that can be used legally in a commercial setting is ketamine. And I know we just talked about Oregon and Colorado and certain state initiatives that are coming out. But other than ketamine, most psychedelic drugs, psilocybin, LSD, MDMA, remain federally illegal. That is a risk that you should not ignore when you are considering your business plan. And the next item on here, when you're considering insurance, make sure that you know that you have the right insurance, that your insurance has the right coverage. Talk to your liability insurer, your DNO, directors and officers insurer. Make sure you know what's covered, make sure you know what's excluded, and make sure you ask the questions to confirm that what you think is covered is actually covered. Make sure you have the correct informed consent forms available to you and developed that are tailored to your business, that are not something that you just get off of a form, or make sure that those informed consent forms are actually tailored to you. and your particular risks. Make sure you have a plan for adverse events, and that everybody in your company is trained in risk mitigation. Something that's not on the slide, but is very useful is, do you know what your document retention policy is? Do you have a document retention policy for your company? Is it in writing? And does it have today's date or a date that's covered? By today, will you be able to produce it? And make sure that the document retention policy complies with any applicable FDA document retention guidelines. Obviously, you don't want to be throwing away documents, before the time that you're required to keep them, but also consider the process, an automated process where you do get rid of documents once there are no more requirements that you keep them. In the context of risk mitigation at clinical trial sites, all of what I just talked about is relevant. But in addition, make sure that all your staff is trained to know exactly what to do if the FDA or the DEA show up at your site unannounced, which they have the right to do, and to show up and in person and request documents. Think about how you can operationalize a procedure, and that you have a procedure in place, maybe, and that it's a written procedure. If people don't remember the procedure, that they can access it. Make sure, obviously, that everybody on your site and your personnel have the adequate licenses, that the documentation of those licenses is kept in a place where you can access it very quickly in case anybody asks. Your CRO should actually have a written risk mitigation policy, but are you familiar with what's in it? And do you know where it is? Do you know how to access that? In the event of a site inspection, consider having all your standard operating procedures stored in a central location that everybody knows where they are. Make sure everybody down to the receptionist knows who to call. For example, if the FDA shows up at your site, does the receptionist know who to call to alert them, hey, the FDA is here? Who is it that answers that phone call? Who is it that comes to the front and takes control of handling the FDA investigator and getting them all of the documents and information that they need? Make sure your policies address data integrity, patient safety, security, record retention. Make sure you're in compliance with the 21 CFR Part 11 regulations about electronic signatures. Most people these days have mobile signature capability, but consider that if you do not, to allow staff to sign documents from their phone to assist with that compliance. And we are running out of time pretty quickly, so I'm going to open this for questions. If we do not answer your question during the session today, we will answer it by email. And one of the questions that we have up here is that I can answer is, what is a trained licensed facilitator? And I think that question was asked in the context of when Natasha was talking about Oregon Measure 109. And so the answer to that question is, under Measure 109, a trained licensed facilitator is actually, it's defined in the Act and in the Oregon rules. The website is oregon.gov/psychedelics, and I happen to know that some of the requirements to be a trained licensed facilitator are, for example, you have to be 21. You have to be a resident of Oregon. And in about, that requirement expires in 2025, but at least now up until 2025, you actually, in order to be a licensed facilitator in Oregon, you have to be a resident of Oregon. You have to pass a background check, and the Oregon Psilocybin Services has a procedure for obtaining a registration and a license, and that you have to take you have to take part and complete a curriculum from one of the approved providers that are approved by the state. And so if you go to that website, the state has a list of approved trainers that you have to sign up for, sign up for, complete that training program, and then there is an exam. And so that is, in a nutshell, what a trained licensed facilitator is. You have to follow all those rules. You know, we are at time right now. There are a lot of really good questions that have come up. We will reach out to everybody who has asked a question by email to answer the rest of your questions. And just because we're out of time, thank you so much for joining us today. It was it was an honor to be able to speak to all of you. We hope the information was helpful to you and your organization. Please reach out to us individually or friend us on LinkedIn. If you have any questions at all, we are happy to discuss anything that we've gone over today and more. As a reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. This concludes our webinar. Thank you so much.